The second case is not something that have been ruled by a French court, but it was an interesting practical case. There was a French director that has signed for writing and directing a Western. This Western was an adaptation of a French comic book. And it was clearly a Western from A to Z. And during the shooting and then the editing of the film, for most probably personal reason, this French director decided to make out of that Western a film on shamanism and, you know, Oriental spirit. It was completely different. I mean, as far as marketing is concerned, it has nothing to do anymore to what have been sold to the initial investors. And as far as film is concerned, you find banks, you find the companies that pre-sell the distribution right and so on and so forth. So at the time, one of those investors came and say, well, we have to take him out the final cut. And here it was obvious that in any case, he would have the final word. And the company that was organizing the warranty of the global financing said to this investor, you can try whatever you want, but the worst case would be that the film will never be released at all, and then your loss will be much more important than if you have a small income on a movie on shamanism. So at the end of the day, the French director won. So moral rights, I think, can't be turned over very easily.
But that's it's a good basic point that when you read a contract, you can't. The point that we're making is that it may say something, but it may be that under the law of that other country, that isn't possible, and that's something you just obviously wouldn't know unless you were a practitioner in that other country. And this is the difficulty, even in co-productions, where you have 3 or 4 countries doing a film co-production together. Each company, each co-producer has their own lawyer in that country, and I would be liaising with them, trying to put the transaction together. You normally are sort of, in some sense, forced to rely on that other party, but one has to be aware that certainly on the English system, a lawyer only acts for his one specific client. He has limited duties to other people in the transaction. But in an ideal world, I suppose what I'm saying is that everybody would always have another lawyer in that other country, so that that lawyer would say, well, it says in the contract here that moral rights are going to be waived, but I'm telling you that under French or German law that's not possible. But not everybody, very rarely does that happen.
Thank you. Any questions from the audience? This is the chance. No? Just a minute, you get a microphone.
Good afternoon. My daughter is 10. She's an author. She has written her first book. I want to ask you, is it in our best interest? We saw a booth. They can shoot a picture and put it on the internet and sells it. We're from New York. Would that affect us, her, in any way? I just want to know.
Can you please repeat the question? We haven't understood it.
They are some kind of media, internet media. They do pictures and put it on the internet. I'm wondering, if I let them take my daughter's picture and put it on the internet, what does that, how will that affect us, her? Is that the right thing to do? I just want to know.
So you mean pictures of your daughter, am I correct? Under French law, Section 9 of the French Civil Code protects right to privacy and the right of your own image, what American would call right of publicity. So if the website you are mentioning can be accessed in France, and if the picture has been reproduced without prior authorization, you could have a claim. In France only.
I think it would be this. I don't know the specific code or legislation, but I think in the UK that you would have, particularly if it's your daughter and your daughter is a minor, but I think in general terms there would be a privacy claim. We are developing more of a privacy right under the European human rights legislation. We haven't had a national privacy right, in the past, but I think there would be. You'd be able to look into that. Yes.
The next thing I want to know, is it wise for publicity interests to let the internet media took our picture to put it on? Would it be of any interest to us? Or it's
well, first, it depends on the nature of the website. Second, it depends on what's linked with the picture. In France, we had a case law concerning the picture of a police officer, and it was taken in the street, so it was public, considered as public, but it was linked with a very aggressive article against the police. So the link of the two was something that gave him a ground to go to court. Another example, we had a very famous politician. He died in Corsica. So Corsica is a specific area in France. So there was a small not documentary, a small thing on the newspaper on TV, and they were mentioning a EU scandal involving Corsican farmer. But they used, while they were speaking of that Corsican farmer scandal, there has a quick shot of this politician's body entering into the church. And the link of the two, there again, gave serious grounds for defamation. So to answer your question, if the pictures of your daughter is used with a wrongful content, you could of course react. But if, for example, the picture of your daughter is used by the US publisher to advertise the book, to some extent, it would be beneficiary for the book.
So I would have to ask the internet producer, what is he going to use it for?
Correct.
And get it in writing or something?
Sorry?
Get it in writing or something?
It's always better to have a clearance on both sides. I mean, the web producer or the website would be very happy to have a privacy clearance on from you, and you will be tranquilized because you will perfectly know the scope of use of the pictures we are discussing.
Okay, thank you.
There is a question.
Given everything that's been happening globally with media, do you see a situation where over the next couple of years there will be a major overhaul of media laws and media rights to address all of the changes? Because everybody complains about copyright infringement. People are saying the moment it's on the web, you lose all rights to it. So aren't the laws more anachronistic now and really needs updating?
I think that is absolutely possible. We are overgoing at the moment, and I think this conference is part of this tendency, this process of digitalization. It is almost finished now of the media. All those media, all cultural media except the computer games, have existed before also in the analog version. Have a problem with transferring this into the digital version, which is some of the problems are called piracy, other problems are of different kind. Altogether, these kind of changes in the marketplace are very good for the creative side, because the producers actually have to have much less people in the value chain who they have to give money to. You know, they can access directly the end consumer, as we have also had in the last panel. But nevertheless, there are problems which arise with this, and these problems are also of legal nature. So that means that at the end of the process, it is probably happening that we will have changes in the European copyright laws and also in the European media regulation laws according to these factual changes in the marketplace. I think to make a remark to the computer game developers, we have experienced dramatic changes over the last 3 or 4 years. Now we have much more self-publishing models than we had before, and we have less problems with piracy, for example, in the games industry because of the specific business models of online games than, for example, in the film industry. On the other hand, the TV companies, TV stations, were very powerful in this analog era because their system was very strong in distributing numerous people. Now their relevance is shrinking. There are more different TV stations. So all these changes actually, finally, they end up into new media law. And so I think at the end of this, you will have a very, very, very different media law. One final remark, and then I finish. On the European level, there is now something going on, rolling on, you could almost say, which is called the digital agenda, which is more like a process than actually a political program. And one of the points I think that which will come out of this digital agenda process is that we will have a much stronger harmonized European copyright and author law. And some people are already raising the question, why don't we have just a unified European copyright law, which would actually be much easier for so many people if we would just have all the same European copyright law. So that is something people are, of course, the French have their doubts because they believe they have invented the copyright law, which is actually true. So they want to keep their original for themselves. But nevertheless, it is a very, very smart approach of the European Commission to say, generally, we would need this for the idea is the market, is the European market, which is when you have one big copyright law, it is more like a unified market than now.
1794, Le Chapelier Act. Sorry.
I think ours was 1778.
Sorry?
The Statute of Queen Anne was...
The what?
Was,
the what?
The Statute of Queen Anne was a little earlier, I think.
Well, I think that what has been done in the EU is interesting when we try to unify the copyright, and there was interesting attempt to unify the copyright. I am just going to mention one where one of us was not in a good mood, and it was Britain. It was about the droit de suite. When an artist is creating a piece of work, then at the beginning he earned very little money because he's not very well known. But then with time he's earning a bit more money, but sometimes he dies, like Modigliani. Modigliani just died without a penny. But then the heirs of Modigliani, at each public sales, could earn a share of the success of Modigliani. It was called le droit de suite. And when in Europe we try to unify that droit de suite, in Britain, because you have a very strong art market, you lobbied very heavily to go against. So as far as copyright unification is concerned, I'm afraid that a lot of countries might have different interests even within the EU.
Just one example, a very, very specific but also very interesting example. There's in German copyright law, there's something called the panorama freedom, which is that when you're standing on a street and you photograph a building, this building, you can use the copyright of the architecture of this building. I didn't study this in detail, but I was told that this panorama freedom, as an exception to the rule of copyright, is not existing in all the countries. I'm not sure if it exists in France, but I don't remember actually. But I know that there are some countries where it doesn't exist, and this is actually a funny thing, because suddenly